Carriers Insurance Education Foundation as a part of the TRS educational services. These seminars are done every second Thursday of each month at 2 p.m. These seminars are presented as an industry update for information purposes only, and they do not qualify for CE credit. If you're seeking CE credit, we do seminars for CE for the first Tuesday of each month at 2 p.m. and you can contact our office to determine if you need CE credit. Next slide, Beth. If you have any questions, please type them in the chat window. Our presenters will be able to look at it and they will respond if they have time. If for some reason we run out of time, because we do want to finish at 3 o'clock today, that's our commitment. We will answer you by email, and then if it's relevant to everybody, we'll make sure that everybody gets the answer to the question that you have. Also, if you end up with any audio problems or other problems with this webinar, please send us a note again in the chat window. If possible, if you lost the webinar itself, you can call us at our 800 number, 800-741-4084, and we'll try to take care of any problems that we might have. The TRS program is designed not only to educate insurance personnel, but also to the motor carriers. For you who participated in our January webinar, we include information that motor carriers can share with their management and their team drivers to lessen the financial impact of an accident. We also have designed it for retail agents to share with their insurers, their motor carriers, so to encourage their motor carriers to do this. If you want to have access and because you did not participate in it, or if you find now it's useful to you to use the information that we had at the webinar in January to give again the motor carriers guidance of what they need to do a post-crash, then you can download that webinar on our website that's listed on our page. If you have difficulty with that, again, call our office and talk to Beth, and she'll walk through that. A part of that webinar that was not presented, that was later sent to you, is some documentation that will help you also to develop a program and give your insured guidance as what they need to do when a crash happens. The January webinar addressed liability and physical damage concerns. Today we're going to address cargo damage. For a for-hire motor carrier with a cargo claim, it's most important to get the claim resolved quickly and the customer satisfied. Liability claims might take time to help the motor carrier to help defend the case, and it could increase their liability premium for a period of time. But in most cases, it does not interrupt their business. A physical damage claim, yes, getting the facts to properly repair and replace a damaged unit can take some time and could be frustrating, but once resolved, meaning the truck's up and running again, the business continues. Cargo, though, is different. Cargo that is damaged is the property of the motor carrier's customers. When cargo damage occurs, this places a strain on the motor carrier's relationship with their customers. If the claim is not handled quickly and to the satisfaction of the motor carrier's customer, then this claim could affect the future business of the motor carrier. Thus, I believe that cargo claims are the most important claims to be resolved fairly and quickly. First concern, have the right policies that cover the motor carrier's operation. There are a lot of policies in the marketplace, all possibly different, because there's not a standard form like auto liability, work comp, and physical damage where we can relate to, we know what most carriers say. Cargo's all over the board. The motor carrier needs to rely on their agents to make sure that their coverage needs and meets their needs. The motor carrier needs to understand both coverages and their obligations under the policy, some of which we're going to discuss today. We are going to talk about cargo coverage in a later webinar when we address the coverage of what the insured needs to be a better insured and information the insured needs to be a better buyer of insurance. Second concern, when the claim happens, the motor carrier needs to take actions to lessen the damage and get the claim settled quickly and fairly. And this is what we're going to talk about today. To assist us with this, the Motor Carriers Insurance Education, the TRS Education Program webinar today, we have two representatives from the Travelers and Marine Department. We have Sam Rizzitelli, he's up in the Hartford area, and we have Sam Tucker, who is in Atlanta, both of which are snowed in, so they're doing it from their house. Anyway, gentlemen, I turn the rest of the program over to you guys.
Thank you very much. And to begin with our discussion on cargo claims, we're going to have a focus on the Carmack Amendment. I think what I've seen over the last couple of decades has been a deterioration in the understanding of the Carmack Amendment as contracts have become a very popular way that shippers and carriers do business. But the Carmack Amendment is still the foundation of understanding between shippers and carriers, and ironically, most contracts incorporate most of the salient parts of the Carmack Amendment to such a degree that you still really need a good, solid understanding of the Carmack Amendment to know what the liability is exchanged and risk is transferred in these contracts. So with that, I think I want to start with the first slide. If we can get to the first slide, please. Beth, there we go. Disclaimer. Give you a second to read that. I'm not going to read it out loud. Give you a quick minute to. There we go. Now, we boil this down to one quick statement. The interstate shipment of goods is a complicated matter. Let's just let that soak in for a minute. Think about it. That's a federal court that I think a judge in a court decision was smart to say that as succinctly as it is. It's true. I think we take for granted in our industry, transportation industry or the insurance industry, we take for granted how complicated the shipment of goods can be. But it's good to see it recognized, and now we're going to get started with some of the more technical parts of this in the next slide here. There we go. Let's talk about the origin of the Carmack Amendment. And it started as an addition to the Rail Transportation Act. And in 1935, Congress passes this new law to apply to motor carriers. Something that's important to think about. What was going on in America in 1935? Not that any of us were there to really remember it, but what was going on in 1930s, the early 30s? We were in a depression. The country was in a depression, and there was a lot of trouble. There was a lot of trouble getting carriers to act as carriers. There was a lot of complication. You think it's complicated now? Well, back in 1930, a carrier that was carrying goods interstate had a lot of trouble not knowing what kind of liabilities they were taking on, not knowing if their limitations of liability would apply, not knowing what the standard of liability would even be. Is it a negligence standard? Is it a strict liability standard? So because of all the uncertainty, carriers did not want to carry goods, or they did so in a very careful way, and I think business in America suffered because they just didn't have carriers aggressively carrying goods to market. So they passed this law. And I don't usually congratulate our Congress for a lot of things, but I do think they did a good job with this one. They built in a standard strict liability rule. So what that means is if the carrier has the goods and something bad happens to the goods, that carrier is going to be liable for the goods. We'll talk in a little bit about some of the reliefs to that liability that are also built in, but it's a strict liability principle. It's similar to workers' compensation. Workers' compensation has that strict liability application where if something bad happens to an employee on the premises of the employer, there's strict liability for that accident that happens. So nobody's fighting over were you negligent, were you not negligent. Did you want it to happen? It's a willful and wanton liability standard. It's just strict liability. It's a good thing to have a uniform application of the standard of liability. The next thing the Carmack Amendment did was it laid out the rights, duties, and liabilities of shippers and carriers for interstate cargo. We'll talk about exactly what kind of cargo this is in a few slides. It allows the carriers to limit their liability if done so reasonably. That's an important thing we'll talk about, how to do so reasonably. And so a good question we like to ask when we do this presentation is, who is the intended beneficiary, carriers or shippers? Something to ponder, something to think about. If anybody wants to put it in the chat and who they think the intended beneficiary is, I'd love to see somebody put that in there. I don't see anybody, but when we do this in live presentation form, we ask those to vote on who they think the intended beneficiary is, and we do get a lot of people who think it was intended to benefit shippers, but the truth is it was intended to benefit carriers, and it did play out that way. It benefited carriers, and it allowed carriers much more certain understandings of what kind of liabilities they were taking on if they carried goods for shippers. What's important, and I have a special note here in each slide that I think it's an important reminder to us, contracts may change. Carmack Amendment. Can we see the next slide, please, Beth? Okay, what does it apply to? Interstate shipments excluding commercial economic zones. There's a couple of those, one in New York, one in Texas. But for the most part, it has to be interstate shipments. It applies to all commodities except for a list of what are called exempt commodities. So we summarized the whole list of exempt commodities because we don't really want to go through 255 different commodities on this presentation. It's easier to understand that it's the things that farmers do, the things that fishermen do, and a couple of miscellaneous classes such as newspaper delivery, some courier services, and garbage disposal. Those are a couple of the miscellaneous classes. Contracts can change this. I've actually read contracts that do say the Carmack Amendment will apply to intrastate shipments. So there are shippers out there that actually like the Carmack Amendment. There are carriers out there that in a savvy way build this protection, the Carmack Amendment protection, into the intrastate hauling too. Not a bad thing to do. A question that does come up from time to time during this presentation is, if we go back to that other slide, the question that comes up is what applies to intrastate? If you don't have the Carmack Amendment, what applies to intrastate? And the answer is it really boils down to bailment law. Every state has a uniform commercial code bailment law that pretty much mirrors the Carmack Amendment for the carriage of goods for the most part. So that's something to think about. Here in the next slide, though, we are talking about the reliefs of liability. And this is worded very carefully. So I'm going to read this specifically. The Carmack Amendment makes the carrier liable without proof of negligence for damage to the goods it transported, unless the carrier can prove. So the carrier has the burden of proving two things. One, it was not negligent, plus the damage to the goods was caused by one of these 5 things. So think about this. Act of God. Tornado comes through. Tornado takes the truck out, cargo's destroyed. Now, unless the carrier had done something negligent, and it's hard to do something negligent, although I did see a case, believe it or not, where a carrier was trying to try to get video footage of a tornado that turned around on them. I think it was in Missouri or one of those Midwestern states, and so there was damage to the goods, and the shipper was able to say, well, you were negligent, you weren't trying to hide under an overpass. You weren't trying to, get away from the storm. You were chasing the storm. And so it's rare, but that's an example of how a carrier can still be negligent. I think we see that applied more and more when there are floods. I think out of all the natural disasters, that hurricane flood stuff is the one that you do see more negligence there. When a carrier has a terminal that's in a known flood zone, it does not take other steps to make sure flooding doesn't occur, or doesn't warn the shipper. You can have negligence with that. But you got public enemy. You got after default to the shipper, and that, I think, after default to the shipper is still to this day the number one defense that a carrier raises to loss or damage. That's when the carrier packs the goods in a certain way. I mean, maybe a shipper's loading count kind of exposure where the carrier never had an opportunity to even change the way something was packed or arranged, and then there's damages as a result of that. You do see that defense raised in those circumstances. Public authority. This comes up. This comes up when and matter of fact, we will all be having more discussions in the future, in the immediate future, over the new FDA regulations that are coming out. They propose new regulations for the safe transportation of goods. These regulations are quite onerous and different than today. When they are finalized, I think it's going to change a lot of things. But think about the exposure. If the FDA or a government authority condemns cargo, that is something that a carrier may claim not to be liable for. Again, they're going to have the burden. They're going to have to satisfy the burden of proving it was not negligent. So if it's in an accident, and then because of the accident, stuff is contaminated, and the FDA goes out to destroy and orders the destruction of the goods, well, guess what? The carrier was probably negligent for having the accident. But that conversation will be had because possibly he's not negligent. Any questions on that? You got the chat box. If anybody has any questions, they can send questions that way. Inherent vice of the goods, that comes up as a what's that?
Say if I'm hauling refrigerated goods and I'm a carrier, if it's a shipper's load and count load, how can I prove that those goods were tendered to me in good condition?
Well, when you receive the goods, if it is shipper's load and count, and that should be noted on the bill of lading. When you get the bill of lading, you note shipper's load and count. If you truly were not given the opportunity to inspect it, it doesn't matter. Then any concealed damage that occurred is not going to be, held. The carrier is not going to be held liable for any concealed damage. Now, an important point. Again, special note here is that contracts can change this. We do see contracts that tweak a lot of these provisions we just went through. I've seen contracts where shippers try to get carriers to be liable for acts of God, and that's one of those things that most carriers push back on and say, no, thank you. I don't really feel like being liable for the acts of God, and most shippers, accept that, even though they try to push some of their terms onto carriers. After default to the shipper, I don't see that shifted often. Years ago, I did see the attempt to ship that, but all of the anti-indemnification movement spearheaded by the ATA and a couple other organizations has kept shippers from trying to push that anymore. But think about the contracts. Again, understanding CARMAC, understanding this law and how it's built into these contracts. You can't really understand the contract unless you understand CARMAC first. And I don't see any questions on that, so it must have been perfectly explained. So we'll go to the next slide and talk about the next slide, please. There we go. So how does it work? All right. To establish liability, the shipper has a very simple process. They have to plead and prove, and they don't have to plead and prove in a court of law. They just tell the carrier, hey, I gave you the goods in good condition. They were delivered by you in damaged condition, and they do have to claim an amount of the damages. They have to say, hey, in this amount, there's an amount of damages here. And we'll get to a little more technicality of that in a couple of slides. Contracts can change this, and I do see this changed a lot in contracts. I do see contracts that try to relieve the shippers of even having to make claims or for the amount of the claim. Next slide, please. Now, once the claim is made, the carrier has a couple of options. One, pay the demand. That's easy. Two, claim one of the 5 outs that we just talked about. 3, pay under a proper limitation of liability. Again, contracts can change this, and shippers love to change some of these. I'll go to the next slide, please. Oh,
you said a proper limitation liability. What would a proper limitation liability constitute?
And we're going to get to that in one of the later slides. We're going to talk about exactly how you lay out that liability. So great question to hold that. Let's talk about the measured damages here. And I think this is, again, another sentence drafted very carefully. So I'm going to read this so that we understand the substance of it. Carmack Amendment specifically limits a carrier's liability to actual loss or injury to the property, subject to valuation rate set forth in the bill of lading. And that's the federal law. That's the Carmack Amendment law right there cited for where that provision is in law. Interestingly, most contracts that I read do use the same words, actual loss or injury to the property. So I think it's a good thing when contracts incorporate known and quantified words like this. So what is that measured damage, though? Exactly. Courts generally measure actual loss or injury as the difference between the market value of the property and the condition in which it should have arrived at destination. So it had a market value if it got there with no damage, and the market value in the condition in which it did arrive. So something to realize here is that salvage rights are built into the Carmack Amendment. There's a lot of dispute over salvage, and we'll talk a little bit about that. But it's important to recognize that the law itself respects the value of property. And I did claims for about 10 years, and all the crazy, glorious international or domestic cargo claims you can imagine. I think I saw it all, maybe. There's a lot of value to goods that are damaged. Just because it's in an accident doesn't mean that there is no value. I can't think of many commodities, many kinds of goods that I just was not able to salvage. There is somebody willing to buy something for at least the scrap value that it has. I do think there is, from time to time, some cargo that has no value or negative value, believe it or not. That's we'll hold the negative value discussion for another day, but just to leave you with an example, think of the dirtiest, nastiest fracking fluid that nobody wants and is considered contamination. That has negative value. Now, contracts could change this. Again, there's a special note of contracts, and they do. I gotta say, this is probably one of the most popularly changed provisions in contracts. The reason is, shippers love to build in their expectation of what the value of goods are, their own goods, and they do. So you do see that, something to pay attention to. This is an area where I think carriers that negotiate contracts need to be careful when they do, to make sure that they don't, if they don't want to, they don't waive the salvage rights, or they don't take on valuation of goods that's just not reasonable. Any questions on that so far? Now, one other point to make in this thought is I say courts generally measure by this difference of market value. Either party, the carrier or the shipper, has the right to propose a different measure of valuation. And let's face it, think about all the different goods that can be carried. There are better, more accurate ways to value goods than just a simple difference in this destination market value. So remember, there's flexibility in there. There's reasonableness and flexibility built in there. And from time to time it does come up, and from time to time it helps resolve issues. From time to time it's actually the reason there is an issue too, though. So it is a good thing to, if negotiating contracts, it is a good thing to really think about that valuation so you're not disputing it. Again, out of all the litigation today over cargo claims, I think valuation is the #1 litigated matter. If anything does go to court, it's not whether a carrier was liable or for what. It's usually over the valuation of that liability. Next slide, please. Let's see what we have coming up next after measure of damages. Limitation of liability. And this gets to your question, Sam Tucker. So carriers are allowed to limit their liability. This is a very good thing. Carmack Amendment allows carriers to do so if done reasonably. And the most popular way to do it is to adopt what's called a tariff. And the tariff ties the rates that are charged to the value of liability. And it could be done on weight. Weight of the goods is popular. Pallets, the volume is volume. But in order for this to work, okay, the shipper has to agree to this limitation of liability in exchange for this shipping rate. So that shipper has to agree to that prior to the haul. So there are a lot of disputes when people are trying to apply limitations of liability, when there's a fight over limitation of liability. I do see a lot of fighting over whether or not the shipper had understood that there was this limitation of liability prior to the shipment. So we'll talk a little bit more about that. And if the carrier fails to effectively limit the liability, shippers recover that full value. Now, again, contracts can change this. And as a matter of fact, I'll just wager that one of the top 3 contract terms I see is something that says carrier's tariff, if any, shall not apply. The shipper's contracts love to, somewhere in there very assertively make sure that there is, no application of the tariff that can limit that liability. Next slide, please. There we go. Timely and proper claim filing. So let's talk about this isn't really a statute of limitation. Carmack allows reasonable time for filing a claim in a lawsuit. Carriers may establish longer time frames. But many of you have probably heard of this 9-month rule, and here's how it works. Carriers are allowed, if they build it in, and this is the part that's in red, if they build it into the bill of lading of the contract, they're allowed to limit the time period that a shipper can put in a claim with the carrier. This is a very good thing. This eliminates the tail on claims. It gives carriers greater certainty to their financial condition, because let's face it, if shippers can't put in claims years in the future, then then you have a solid understanding year to year of where your liabilities are. It's a good thing for the financial health of carriers in the transportation industry. I do think this is one of the most important provisions of the Carmack Amendment, and I do see this built in most of the time to bills of lading. A standard uniform bill of lading that is used in the industry does have this term built in, and it's simple. If a shipper does not put in a claim within 9 months of the date of delivery, then they have no claim. Think about that for a second. A lot of people miss this point. Every year, there's millions of dollars paid by carriers or their insurers to shippers, and nobody asks the question. You know, is this claim beyond 9 months of the date of delivery? So I think this is one of the provisions of the Carmack Amendment that has lost some understanding. And I'm not saying the limitation of liability applies. I'm saying no liability applies. If it's 9 months and 2 weeks after the date of delivery and now a claim is submitted, that carrier is not liable at all. Think about that. No liability. We're not talking about arguing over values or salvage or anything. There's no claim. There's no right to a nickel. You have 9 months. If, again, most important reminder here, you have to build that into the bill of lading of the contract of carriage. And I'm guessing about 98% of all bills of lading and contracts of carriage actually have that built in. I mean, that is what we see. 2 years and a day, it's a little bit of a statute of limitations on putting in, filing a lawsuit. And it's very similar to what I just said. It's built into the bill of lading or contract of carriage that the carrier must be sued within 2 years and a day of the now this is what's important, on the date on which a claim is denied, not date of delivery. So think about the claim process with the shipper, and then if the carrier denies a claim or part of the claim, they build this in, this 2 year and a day rule, they build it in. If somebody sues outside of the 2 years and a day, that lawsuit is thrown out of court on day number 2, in what's called a summary judgment motion, and those win 98% of the time. So these are a couple of really good rules to create certainty to the financial condition and liabilities of carriers. Something to think about, something to pay attention to, especially when negotiating contracts. Don't see any questions so far, so we'll go on to the next slide. And again, just a reminder, if anybody wants to, in the chat box, submit a question, we can take that. Now, here is a little bit of the process, which is built into what's cited here is a Code of Federal Regulation. This federal regulation called 49 CFR 1005, or you'll find it in 373B. This is a federal regulation, which I encourage everyone to Google it, pull it down, and print it out and read part of it, because you'll like it. As scary as that sounds, I'm telling you, there is a federal regulation out there that if you pulled it down and you printed it and you read it, you would like it. It's really ultimately it's the Department of Transportation's outline of the Carmack Amendment claim process. And I have to say, it is a very good claim process. It's an excellent claim process. And if carriers and shippers and intermediaries all understand this regulation well enough, when they do, and there's a lot of times that most do, it always provides a much happier claim process for all the parties involved. It's fair and it's honorable. And if people follow that, and people want to follow that, it really helps with disputes. Now, there's a few requirements, and I want to go through them because they're very important. It has to be a written or electronic communication. It can't be a phone call. If somebody calls 8 months after the date of delivery and says, I'm the shipper, you destroyed my cargo, I want you to pay. If that carrier waits 5 more weeks, he doesn't have a claim. That carrier has no claim that shipper can recover on. It has to be a written or electronic communication. It has to contain sufficient facts to identify the shipment. It has to assert liability against the carrier. All these are required. And it has to make a demand for an amount certain, specific, determinable amount of money. And when I was in claims, I used to call that the ceiling. I used to love this claim process. I used to call that the ceiling because that helped me know exactly what total amount of the ceiling would be on a cargo claim. And most claims settle out south of that a little bit, and some settle for exactly that because it's the right amount. But if the parties follow the process, it's a really good process that facilitates the least amount of disputes. And again, these 3 points are important to realize that that's a proper claim. If you don't have a proper claim made in 9 months, you don't have a claim. Let that soak in for a second. And remember, contracts can change this. Contracts do change this. Shippers always love to delete some part of this. And I think that's something that carriers should pay close attention to if they do let shippers get away with that. Let's check out the next slide, please, and see what we have in the next slide.
What would you say is the of those four? What's the one that's usually missing or the hardest to prove or establish on behalf of a shipper? Which one's the trip up?
Good question, and it's I'll bet you written communication comes up where there was nothing in writing. That does come up, but out of the four, I think an amount certain is probably the biggest trip up for a shipper. I'll bet you that there are more claims where shippers blow that point than any other point. Great question.
They get the information submitted to them in a timely fashion, but the problem is they can't come up with the exact amount that they are assuming or certain the valuation of the goods. Right.
Or the in the demand they just say you owe me a lot of money for this. You owe me but they don't actually put a specific amount.
Right.
Great question. Okay, so the next slide we have here is on the waiver of CARMAC. This is important, and this is important to pay attention to, because what I want to say is this. We talked about what CARMAC applies to, interstate shipments, non-exempt commodities. Well, guess what? This is a federal law, and this is designed by the U.S. government that says it shall apply. It shall apply. And when the federal government, leans on its supremacy, it gets away with that, and it does apply. It has in it an exception, though. But if you don't follow that exception perfectly, then it applies. So let me explain this, and I'm going to give you an example of something I saw, which is kind of amazing. I think cargo claims, you can always find something amazing. It is the kind of subject matter that does not have a lot of boring days. So in order to be effective, the waiver, you have to waive the CARMAC amendment in writing. It has to be expressed in writing. And the parties are then left with the, to contract either orally or in writing, and most of the time it's a written contract for again, the rights and duties. If expressly waived, shippers in a claim can allege preempted claims. I'm going to talk about that a little bit, but let me talk about it right here. One of the additional features of the CARMAC amendment is that it says you're only allowed to make a claim for remember we in the prior slide we saw for the actual loss or damage to the cargo. So that doesn't include a lot of consequential damages, and one of my favorite examples of that, all the extra, contractual stuff, or misrepresentation, bad faith, deceptive trade practice. These are all state lawsuit, torts that are tacked on to cargo claims. But CARMAC says if CARMAC applies, a shipper is not allowed to claim any of that nonsense. A shipper is not allowed to claim, and again, my favorite example of this was on a household good mover. There was a very large claim for emotional distress attached to some personal goods and pictures and other things like that. And I think in that case we were able to assert the CARMAC amendment and preemption and we knocked out about a $700,000 exposure for a carrier who otherwise may have been exposed to that. If Carmack had not applied, carriers are exposed to all these other, I like to call them cuckoo claims, but those are real. So that's the waiver of the Carmack Amendment. That's what I wanted to say about that. I think I wanted to say one more thing about that, but maybe we'll go to the next slide and it'll jog my memory. Okay, contractual waiver. So let's summarize a little bit here. Contract does not waive Carmack. Oh, I'm going to give you an example. I'll do it here though. The shipper retains the benefit of strict liability features and the burden of proof, burden of defense. Carrier retains the benefit of limitations of liability, claims and suit filing limitations, and preemption over state law claims. And before we go to the next slide on this waiver of Carmack, let me give you an example for you to think about. Had a shipment of nuclear kind of material, and it was hit by a tornado, Joplin. It was during the Joplin tornado. And what's interesting about that was the contract used was a very construction style contract. It was not a transportation contract. It was more of a construction contract. So it had terms in it that were very strict, transferring all risks for act of God and everything, transferring everything to the carrier. And the carrier had signed that contract and had assumed this liability for acts of God, and this was a very large nuclear material claim, and it was ugly. Well, as lawyers started doing their homework, everyone pretty quickly figured out that in that construction-style contract, the parties did not properly waive the Carmack Amendment. Nowhere in the contract did the parties waive the Carmack Amendment. So, because it was an interstate shipment, the carrier had the benefit of saying, wait a second, that was a tornado. I'm not liable for the act of God. I didn't do anything negligent. Shipper, you're on your own. And the shipper went screaming up and down the phone lines, yelling because they had a contract. But the irony is this. Who was that shipper, my friends? Who was that shipper? And we had the U.S. federal government. So when the U.S. attorneys figured out that they didn't follow the federal law, the claim just went away. And so it's just a good example of really how all these technicalities come together and how much they really mean. That's why, as we talk about cargo claims, it's real important to lay the foundation down. In the next slide, though, I want to show you a couple of examples of waiving Carmack Amendment and not waiving Carmack Amendment. So we go to the next slide. We will look at that. And you have to ask yourselves a question. As we go to the next slide, there it is. This is a clause that comes right out of the ATA's model carrier broker agreement. It's on the website, the ATA's website, and this is just an example of waiving Carmack. It's a good job of waiving Carmack. But ask yourselves a question. If you're a carrier, if you represent carriers, if you are looking out for carriers' interests, do you want to waive the Carmack Amendment? Sometimes it's okay, but just ask that question. Remember, Carmack is designed to benefit carriers. When we waive the Carmack Amendment, there's a lot of uncertainty. It's possible to have a lot of uncertainty. It's possible to do it in a very responsible way. It doesn't create uncertainty, and the ATA, has done that, as a matter of fact, and I'm going to show you how. And this is a little tip for folks here. If we go to the next slide. In the next slide, I will show you an example of securing the Carmack Amendment. And ironically, this is in the same contract as the clause I just showed you waiving the Carmack Amendment. So think about this. The ATA, and I think this is brilliant, the ATA put together a model contract. The model contract says we're waiving the Carmack Amendment. The rest of the contract goes on to incorporate what? The Carmack Amendment. So that's okay. All you did was codify the Carmack Amendment into a contract. And I think that's important because that model contract floats around all over the industry. And I got to say, even Walmart's contract, or some of the most onerous shippers in America, still have the fundamentals of Carmack built in and are willing to negotiate right back to Carmack on most points anyway. So understanding Carmack is critical to understanding the cargo claim. Being prepared for the cargo claim before the cargo claim occurs is 90% of the battle. 10% is actually settling it out. But all the work should be done prior to a cargo claim, and all that work has to have a solid understanding of the Carmack Amendment built into that hard work. Then you're ready for a cargo claim. And we'll go to the next slide and talk a little bit about that. Tucker will give us some thoughts on that. If we get to the next slide here. Tucker, do you want to talk about the cargo claim kit?
Yep. Thanks, Sam. I appreciate it. Yeah, if accidents, you definitely want to have a lot of things in order, obviously. And one of those things that we definitely recommend is the cargo claim kit, every unit, including things like cargo and policy, insurance contact information, even pen and paper. You'd be surprised how quickly those kinds of small things disappear as quickly as possible. A disposable camera, pictures are worth 1,000 words. It's cliche, but it's the absolute truth. If you have a disposable camera in there, you can take pictures of the damage to the goods, the damage or the parts that aren't damaged, and be able to understand a little bit better about potential recovery there. If you don't have a camera, you can always use driver's cell phone, or obviously if the truck overturns and it's down the 35-foot ravine, the disposable cameras in the glove compartment down there is not really helping you. So the driver's cell phone could also be used as a good opportunity to take some photos. Also, the preferred towing and salvage companies. A lot of folks these days are moving towards a network towing approach where you actually have a lot of folks already lined up to take care of your towing needs across the country, or even your salvage needs across the country if you actually do have a cargo loss. You can have those lined up ahead of time and actually put into the cargo claim kit in your tractor to know who to contact in case of a cargo accident like this. Something else you suggest is also just having one laminated, put on a 3x5 card or smaller, and laminate it and put in the driver's wallet. Because again, in case you have that 35-foot ravine type of loss, you can't really go down there and get the information out. That's a little more difficult. As we'll see on the next slide, you can take a look at some of the other different things you really want to make sure you want to have as a result of the cargo claim. When you're talking about submitting a claim to your insurance agent or the carrier, you want to have a lot of different things available for processing that claim effectively and efficiently. Definitely the bill of lading, shipping document, freight invoice, and all the documents that go along with the actual shipment and identify the shipment. Any contracts you have with the shippers or the broker or the consignee, definitely have those in hand too. Written driver statements and police report information. Just a note of caution here, you definitely want to make sure that the written driver statement is done thoroughly and truthfully as possible, because you never want something to come back and haunt you later on. So you always want to coach your drivers to specifically be as thorough and as accurate as possible. Also good information on the location of the cargo. Where's the cargo? Who can we contact to take a look at the cargo if you're talking to claims adjuster? And then again, here goes back to the photos or videos of the damaged goods or the undamaged goods, just trying to separate what is damaged, what's not damaged, and be able to understand, kind of establishing proof of loss. On the next slide, you'll be able to see when you have a specific type of loss. On the next slide.
Yep. Next slide is there. You're talking about theft, right?
Yep. speaking specifically of theft, absolutely. Theft claims are a little bit different than your standard accidents or claims involving collision. Some of the things you definitely want to have better understanding of and better information of are the specifics in terms of the actual vehicle that you're driving, the conveyance, the trailer, if the trailer has any kind of specific markings, or if the tractor trailer is in a specific color. You definitely also want to know about the last known location. You know, a lot of theft actually happens at fixed parking areas or places where the cargo is actually stopped. You know, we always say, you know, cargo at rest is cargo at risk, and that's another little cliche, but it's true. Most of the cargo stolen in the United States is actually stolen when the vehicle is typically parked and usually unattended. And also you want to have information about the driver. And when you're submitting claims, you want to have information about the driver, or if you're actually, you know, first off, to even think about it, you know, want to talk about who you're talking to first. You want to talk to the police first, and then you want to talk to the insurance company. Or if you also have a cargo theft task force available, you want to talk to the police or the cargo theft task force to get that information on the street as quickly as possible, because that's information that can lead to the recovery of the goods quicker than actually trying to file the claim. As everybody knows, you know, shippers want to have their money back, but they'd much rather have the cargo back. You know, going back to Tommy's original point that, you know, the actual cargo affects the business more so than the liability or physical damage losses will. So having that cargo back can sometimes mean a heck of a lot more to the shipper than actually having the money to pay for it, the lost, damaged goods. You also want to have specifics about the physical cargo that's being carried. You know, we have the serial numbers, any kind of unique markings, the manufacturer of the goods, how many pallets they are, if they have any kind of anything that kind of differentiates them from something else you'd be looking for. So good information to give the police or the cargo theft task force is definitely information specifically about the cargo, and then information specifically about the conveyance or the truck and tractor and driver that had it. On the next slide, we want to talk about a little more. There's some good things to remember. You have a right, but also a duty to mitigate cargo losses. You know, you want to retain all the undamaged goods and as much as damaged goods as possible. You know, a lot of the tow companies or salvage companies want to take as much of that as possible, but as much as you can retain of it, you want to be able to prove the loss. You know, have proof of loss. There are salvage vendors across the country that can help you protect the cargo. You can always.
Sam, let me jump in real quick. I want to make one point on the mitigating of the cargo, because I think I could bring some of this home with our discussion over Carmack here. If a carrier waives the Carmack amendment, and we do see this from time to time, we see this popularly enough that I do think it's something to pay attention to. After waiving the Carmack amendment, you can also waive your salvage rights. And there are a lot of contracts that actually do that, especially with food and beverage manufacturers and even Walmart, like I mentioned earlier. There's a lot of contracts that have waiver of Carmack and then waiver of salvage. So when that happens, you have partial losses becoming total losses. And but so I just want to make that point so folks are at least astute to the exposure. I think that's an exposure that's not insured by a lot of insurance, and I think it's an exposure that ends up causing a lot of commotion. So as you discuss this, just keep that in mind. If you do have the salvage right, then you also have that duty to mitigate. And you're right, you said it the right way, Sam. You know, you have the right and the duty to mitigate once you're in that ballpark, and that's the better ballpark to be in anyway. But go ahead, I'm sorry.
Absolutely, no, and I appreciate that. Yeah, absolutely. And going back to, I mean, set up that network of preferred towing vendors across the country or wherever your hauling radius is, and then any of the salvage guys, having some salvage companies in mind ahead of time can help you greatly reduce and mitigate those losses. And the ability to do so can, not only help you come claim time, it can also help you come your insurance renewal time. So always good things to keep in mind. On the next slide, we just want to thank you for your time and appreciate your attention today. I want to turn it over and see if anybody has any questions that we can answer for anyone.
as you all think about questions to ask Sam, first off, I want to thank Sam for your time and effort today to put together to do things. The part of the discussion, if you all were a part of our discussion last January, or in January, concerning what does after crash, are very similar here. One of the key components that I emphasized in that case and Sam's emphasized today is to have a preferred towing operation. Most of the exasperated towing bills are, in my opinion, a derivative of the cargo attempting to be salvaged, attempting to be saved, attempting to have those things done. And if you have a towing service that you can trust to do those things, it will make the claim go better once it happens. Also remind you that it's important to work with your clients and let them know what happened and their urgency on that. The last thing you mentioned concerning waiver of salvage or not, and even waiver of the Carmack Amendment. This is why, again, we encourage people who are motor carriers to do business with agents who understand these kind of processes and understand how this stuff works so that they can tailor the right coverage so at time of loss the customer can be satisfied as well as the motor carrier being protected. With that, then, we thank you, everybody, for attending today. Our hour is about up. We will remind you that we're doing another seminar next month, again, on March the 13th, which is the Thursday, not a Friday, at 2 p.m. There we're going to talk about the independent contractor update, stay current with all the activities. Some of you might be aware that there's been a new court ruling or a new law that's passed in New York concerning this, and this is an ever-changing environment, and this is becoming critical as they're trying to enforce through Congress and the state legislatures the enforcement of the contract. To that end, we thank everybody for your attention. We hope that you got something out of this hour, and we appreciate your continued support for the Motor Carriers Insurance Education Foundation and the TRS web educational efforts. If you have any questions or concerns, please feel free to email our office at the TRS@ibci.net, or feel free to call in our office, Beth, and you can talk to her or me about any questions. And if you want more information from the presenters today, we can get you in contact with those people. To that end, we're out of here. And again, Sam, thank you for your time, and y'all stay warm. Bye.
Thank you. Take care.